Akere Dolu,
Good morning, my lord.
good morning. How are you?
I'm fine, my lord. Good morning, sir.
Yes, you intentionally did not put on your
Video, I'm switching on now, sir.
okay. And then my own video is having issues. Can you see me?
No, sir. Not at all, sir.
I can see my own, this thing is blank while I can see you live.
Thank you,
And,
sir. I can't. I
and
think the video is.
my video is on.
I'm sorry about that, sir.
Yes. My video is on, my audio is on, and that's why you can hear me.
Hear you very well, sir.
Anyway, thank God you can hear me.
Very well, sir.
I'm sure the video will come. Okay.
Okay, the video is on now, sir.
Yes.
Thank you, my lord.
What of your colleague? Is he not?
I can't find him online personally.
Ayenaki.
Ayenaki, yes.
Another lawyer in office. He has lawyers, but it's okay. We'll proceed. It's after 9.
Thank you, my lord.
Let's take appearance.
May I please, my lord?
Yes.
OF, Akere Dodu, my lord. CLO, Chief Legal Officer, Gondo State Ministry of Justice.
You wait for me to finish writing the name that is as long as my own name first.
I'm sorry, my lord.
CLO.
CLO, yes, sir.
Okay. Chief Legal Officer.
Chief Legal Officer, my lord.
Not Corps Liaison Officer.
Sir?
Not Corps Liaison Officer.
No, my lord.
Because I remember I was a CLO. And that
okay.
CLO then meant Corps Liaison Officer.
Oh, that is interesting. Thank you, sir. I pray for the respondent, sir.
Ondo for the defendants.
Yes, sir. Yes, sir.
Bachelor, what did they say? Yes. Okay, the matter is for judgment.
At God places.
Judgment is ready.
We're grateful, sir.
Okay. This is the judgment of the court. Judgment day. Earthly judgment day, not the heavenly judgment day. In the National Industrial Court of Nigeria, in the Akure Judicial Division, holding at Akure before His Lordship Honorable Justice K.D. Damlak, dated this 29th day of September 2021, suit number NICN/IS/09/2019, between Mr. Idigbe Olorunso O and 33 others, all listed out. I don't think I need to read them one by one. They are all listed out. Yes. Yes. The first 19, the first 18 are disengaged staff of Staff Secondary School, Rufus Giwa Polytechnic, or formerly Ondo State Polytechnic, or then the 19th to 34th claimants are disengaged staff of Staff Primary School, Rufus Giwa Polytechnic, or formerly Ondo State Polytechnic, or and defendants are 1, the rector, Rufus Giwa Polytechnic, or 2, the governing council, Giwa. Then third, the Rufus Giwa Polytechnic, or formerly known as Ondo State Polytechnic, or Judgment. 4 claimants, that is, the present first, second, 19, and 20th claimants, initially filed a complaint on 23rd October 2020 for themselves and on behalf of unnamed staff of secondary and primary staff schools of the third defendant. By a motion filed on 10 March 2021 and granted on 18 March 2021, the claimants amended their complaint and listed all the other staff. The defendant filed a memorandum of appearance on 6 January 2021 and a statement of defense. The claimant filed a reply to the statement of defense on 31st January 2021. The defendant filed an amended statement of defense on 24th May 2021. On 28th October 2020, that should be 2021. Okay, no. Yeah. On 28th October 2020, Lanet Ayenakin of Claimants Council applied for the matter to be heard on record pursuant to Order 38, Rule 33 of the rules of this court, but Lanet Akere Dolu of Counsel for the defendants did not concede, and the case was adjourned to 26 November 2020 for hearing of evidence. On the 26th November 2020, Lanet Famoshe, appearing for the claimants, informed the court that defendants have agreed to hearing on the record, but defense counsel was not in court. The court adjourned the matter to 2nd February 2021. To 2nd February 2021 for adoption of final written addresses. If the defendants file a written address or else for hearing of evidence, both parties filed final written addresses. On 18th March 2021, Lanet Ayenakin introduced his motion for amendment filed on 1st March 2021. Lanet Akere Dolu indicated his opposition to the motion and also introduced his motion dated 23rd February 2021. The court accordingly set aside the agreement to hear the matter on the records and discountenance the final written addresses filed by both counsel. After the hearing and granting of the motion, both Ayenakin and Akere Dolu agreed to hearing on the records on 25th June 2021. The final written addresses were adopted on 29 June 2021. On that day, Ayenakin of counsel to the claimants moved a motion seeking to file a reply to the defendant's final written address and to front-load a document, and also adopted his final written address. Lanet Akere Dolu moved his counter affidavit to the motion and also adopted his final written address. The claimants pray for the following reliefs. A declaration that the disengagement of the claimants from the service of the employment of the third defendant is wrongful, illegal, and void. B, an order of this honorable court restraining the claimants to the employment of the third defendant with the payment of, I take B again. An order of this honorable court reinstating the claimants to the employment of the third defendant with the payment of claimants' salaries, entitlements, promotion, and bonuses from date of disengagement to the date of judgment and thereafter. Alternatively, an order directing the defendants to pay the gratuity, pension, and other entitlements of the claimants under the third defendant's condition of service consequent upon the disengagement of the claimants from their employment. Case of the claimants. It is the case of the claimants that first to 18 claimants were staff of the staff secondary school, while the 19 to 34th claimants were staff of the staff secondary school. No, staff primary school. Rufus Giwa Polytechnic, or that all the claimants were appointed, confirmed, and promoted by the second defendant on behalf of the third defendant. That the appointments of the claimants are regulated and governed by Rufus Giwa Polytechnic, or Senior Staff Manual Rufus Giwa Polytechnic, or Senior Staff Career Structure, and the laws creating the third defendant, Ondo State Polytechnic, or Edict 1990, that their appointments enjoy statutory flavor. On or about the 5th August 2019, they were issued a letter informing them that the primary and secondary schools of the institution had been closed down, that their services were no longer required, and that they have been disengaged from the services of the third defendant, that their disengagement was wrongful, unlawful, void, and in contradiction of their conditions of service and all established principles of labor law, that as statutory employees of the defendants, their appointments cannot be terminated when they have not attained the mandatory age of retirement, which is 65 years under the claimant's conditions of service, that disengagement as a result of close down of a department, be it staff primary or staff secondary schools, is unknown to claimants' conditions of service, that they were not employed by the staff primary school and secondary schools, but by the second defendant or the third defendant. As such, the close down of the staff schools has nothing to do with appointments of the claimants. Alternatively, the claimants claim that they are entitled to be paid gratuity, pension, and their entitlements as contained in the defendant's manual. I can see Iche Chime. Okay, Chinda, are you for this matter?
Yes, my lord.
Okay, you are from.
Yes, my lord. May you please?
You are for the claimants.
The claimants.
You are for the claimants.
The claimants, yes, my lord.
Okay, I take mental notice of your presence. We will record your attendance after the judgment. Thank you. Case of the defendants. The defendants, on the other hand, contend that the claimants were employed by the second defendant for and as staff of the third defendant's primary and secondary schools, that the appointments of the claimants are not regulated by and are not meant to be regulated and governed by Rufus Giwa Polytechnic or Senior Staff Manual Rufus Giwa Polytechnic or Senior Staff Career Structure and the laws creating the third defendant, Ondo State Polytechnic or Edict 1990, but by the specific terms and conditions stated in their various letters of appointment. The disengagement of the claimant from the services of the third defendant is not in violation of their condition of service as contained in their respective letters of engagement and letters of regularization, to the effect that the appointment may be terminated by either side by a month's notice in writing or a month's salary in lieu of notice, that the claimants were rightly, lawfully, and validly disengaged from the services of the staff primary and secondary schools due to the circumstances beyond the reasonable control of the Polytechnic, that is, financial means of the third defendant to maintain the schools, that were putting too much pressure on the financial well-being and other statutory responsibilities of the Polytechnic, It became impossible for the Polytechnic to continue to run and sustain the schools financially and to pay for the services of the claimants and other supporting staff of the schools. In bracket, security personnel, cleaners, contractors, etc. The closure of the schools for which the claimants were solely appointed as teaching and non-teaching staff automatically and literally implied their disengagement by the second defendant as the staffs of the staff primary and secondary schools, that is the department, that it is not one of the statutory mandates of the third defendant to establish and run staff schools. The defendant shall show at the trial that the closure of the staff schools that at the closure of the staff schools, the defendants made arrangements to incorporate and absorb the outstanding services of the affected staff into the services of Ondo State Teaching Service Commission and its primary school equivalent, from where many of the teaching staff of the staff schools crossed over to the staff schools, but the claimants roundly rejected the offer outrightly. The letter dated 23rd October 2019, titled Reabsorption of Disengaged Staff of Rufus Giwa Polytechnic Owo. Letter of appreciation is hereby pleaded. Unfortunately, Akere Dolu, I did not see anything attached to your processes. I saw the pleading of these documents, but I searched my files. I did not see the document anywhere at all.
My Lord, we filed all of those documents. We filed and we served.
Probably you did not attach to all the copies, and then unfortunately for the copy that didn't have them. But I'm just pre-informing you, I didn't see them. That's the justice. I didn't see any of them.
My Lord,
Claimant final written address.
My Lord, I pass.
I'm not saying no. All I'm saying is me, I didn't see them. I'm just telling you ahead of time, me, I didn't see. That is all. Yes. In his final written address, Learned Ayenakin Esquire submitted that in the case of unlawful termination of appointment or wrongful dismissal of employment protected by statute, is for the claimants to ascertain or place their condition of service before the court and show in what ways their conditions of service were breached by the defendants. In terminating the employment of an employee protected by law, the employer is duty bound to observe and comply with the condition of service strictly. This is because any infraction by the employer will be declared or held to be invalid and void by the court. The position of the law is clear on this contention that where parties are contending the condition of service of the employees, the court should make recourse to the letters of employment, to ascertain the conditions of service of the employees. By paragraph 07 of the letter of appointment of Idigbe F.O. dated 15 February 2008 and by a letter dated 28 November 2011, the letter of confirmation of appointment, it is expressly stated that the appointment of the claimants is till retiring age and that it is subject to the regulations of the third defendant. The letter of appointment dated 26/2008 shows in the first paragraph that the second defendant appointed the claimants for the third defendant in the Department of Staff Secondary School. The identity card and pay slips of the claimants attached to the claimants' reply show lucidly that claimants are employees of the third defendant and they are in the department of the third defendant known as Staff Primary and Secondary School. The claimants were not disengaged as a disciplinary measure. The termination on ground of services not required is foreign to claimants' condition of service, being statutory employees who cannot be terminated by notice of payment of salary in lieu of notice. The termination on ground of services not required is only applicable in a master-servant relationship. Defendant's final written address. Submitting for the defendants, Learned Akere Dolu posited that the court that for the court to unravel the issue, the whole of the composite document containing the conditions of service available before the court must be dispassionately considered, that the only available documents before this court are the various letters of appointment, letters of confirmation of appointment, and letters of regularization. Counsel submitted further that the clause, the appointment may be terminated by either side by a month's notice in writing or a month's salary in lieu of notice, and in the event of the Polytechnic being prevented from carrying out the terms of the employment by force majeure or any other circumstances beyond the reasonable control of the Polytechnic, the employment shall be deemed to have terminated with effect from date of the occurrence of such an impossibility is contained in every one of the letters of offer of appointment attached to the claimant's originating process. Therefore, the termination of the claimant's appointments due to the closure of the staff schools and the undertaking to pay a month's salary in lieu of notice is lawful, legal, and valid. That where an employment is claimed to be governed by rules and regulations backed by statute, a person who claims protection under those rules and regulations must show that he was employed under those rules and regulations, otherwise he cannot rely on them. That where an employment is determined by the agreement of the parties simpliciter in accordance with the terms of the contract of service, under no guise can statutory flavor be attached to it, but must be regarded as mere master and servant relationship. That the law is right that a servant who complains that his employment has been wrongfully brought to an end must found his claim on the contract of service and show in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. That the failure to tender the senior staff manual or the senior staff career structure, the court is hindered from exercising its jurisdiction to determine whether or not the employment enjoys statutory flavor, and even to determine whether or not the employment was wrongfully determined. Court decision. A. The motion to file reply and to download a document. That's where we're starting. By a motion dated 14 July 2021 and filed on 16 July 2021, the Claimants Council prayed for leave to front-load the third defendant's manual, which was omitted from the documents front-loaded, and for extension of time to file a reply address. In the accompanying affidavit, it is deposed that while filing the processes, the third defendant's manual, which was pleaded and listed as one of the documents to be relied upon, was inadvertently omitted from the attached documents, that the claimants were out of time to file a reply and need leave of court. There is attached a written address which addresses the issues raised in the affidavit. In a 9-paragraph counter affidavit, the relevant paragraph being paragraph 6, I to X, it is deposed that pleadings have closed and final written address is filed, and one of the issues or defense raised by the defendants is the failure of the claimants to exhibit or tender the third defendant's manual. So the application to front-load the said document is to frustrate the defense of the defendants. That allowing the document to enter into the court record will deny the defendants fair hearing and create a suit for the claimants where none existed. That the document attached is not in a form admissible by this court. That the said manual did not form part of the claimant's case. The council's written address is in line with the council's written address is in line with and supports the counter affidavit. Nothing is said in opposition to the prayer to file a reply. It is deemed that this arm of the application is not opposed and same is accordingly granted. With respect to the opposition to the front-loading of the staff manual, it is pertinent to first find out if the said third defendant staff manual was ever made a part of the claimant's case. In the extant process, the amended complaint of 12th March 2021, there is a separate list of documents in which this document is listed as number 12, and it is also listed in the body of the complaint at page 2 of the complaint as number 11. The said manual is referred to and pleaded in paragraph 14 of the statement of facts. What is missing is that the said manual was omitted in the documents attached. The claimant's deposition that it was inadvertently omitted in the attached documents is therefore justified. Accordingly, the complaint of the defendants that the front-loading of this document at this stage will deny them fair hearing and create a suit for the claimants where none existed is nothing but sentiment. This court will not determine a case based on sentiment. This is even more so that the said manual is a subsidiary legislation which the court could take judicial notice of and rely on same without it being front-loaded. As for the argument that the manual is not in the admissible form, the manual is a photocopy, but there is no prescribed form in which a legislation is to be given to the court, even if tendered as evidence. No injustice is done to the defendants by allowing the claimant to front-load a pleaded document that was omitted in the attached documents. On the whole, the objection fails and is dismissed. The third defendant's manual is deemed front-loaded, and the claimant's reply address is improperly filed and served. Reply of the claimant's counsel. It is pertinent to summarize the reply of the claimant's counsel hearing. It is the contention of the claimants in the reply that in a suit bordering on employment, the totality of the cases of parties are determined by the terms and conditions of service and not by extraneous matters. That force majeure is not a principle of general application in employment contracts. It is a specific principle that must be contained in the contract of employment or the law establishing the employee's workplace before it can be invoked. That the statute establishing the defendant did not create departments but gives the institution the power to create departments, and the letters of employment indicated that the staff secondary school was a department, that the doctrine of frustration do not apply to contract of employment. Merit of the case. The third defendant is Ondo State-owned polytechnic. It created or established a staff primary school and staff secondary school and employed the claimants therein, mostly as teachers. Due to financial difficulties, the defendants closed down the staff schools and consequently disengaged the claimants for services no longer required. The claimants claim that their appointment with the third defendant enjoys statutory protection, and so the closure of the staff schools have nothing to do with their employments. The defendants deny statutory protection of the claimants' employments and plead force majeure. The claimants want reinstatement or, in the alternative, payment of gratuity and pension. The defendants deny the entitlement of the claimants to any of the relief sought. This court is thus called upon to determine the rights of the parties. The issue for determination, therefore, shall be whether the claimants have established their entitlement to any of the relief sought. In determining the above issue, we shall ask and answer the following questions. 1. Do the employments of the claimants enjoy statutory flavor? 2. Is the employment of the claimants necessarily affected by the closure of the staff schools? 3. Can the claimants be terminated with 1 month's salary in lieu of notice and no more? So, to determination of the issues. The contention of the claimants that their employment enjoys statutory flavor appears to be more in the realm of assumption, on the basis that the third defendant is a creation of statute. Claimants' counsel did nothing more to show that statutory protection. It must be pointed out here that the first point of call in determining if an appointment with a statutory body is protected is a recourse to the statute creating the body or institution to find out what the statute provides in relation to the particular office of the employee, as it is now settled that it is not every employment with statutory body that enjoys statutory protection. See Cosmos, C, NADI, and National Air Care Center, and another 2014 LPLR, where the court held in employment with statutory flavor, that is employment governed by statute, wherein procedure for employment and dismissal of employees are clearly spelled, and the employment cannot be terminated other than in the way and manner prescribed by the statute concerned, and any other manner of termination inconsistent with the statute is null and void. Such is applicable in contracts of employment under the public and civil service of the federation, states, local government, and agencies of government. In Federal Medical Center, Ido, Ekiti, and others versus Isaac Olukaede Olajide 2011, LPLR 4150, the court held. For an employment to be held to have statutory flavor, the following conditions must be met. 1, the employer must be a body set up by statute. 2, the establishing statute must make express provisions regulating the employment of the staff of the category of the employee concerned. In a plethora of legal authorities in recent times, the Apex Court has given a clear distinction between employment with statutory flavor and other employment. In employments governed by statute, procedure for employment and discipline, including dismissal of an employee, are clearly spelled out, whereas any other employment outside the statute is governed by terms under which the parties agreed to be master and servant. What then did the statute creating the third defendant provide for the employment tenure and discipline of the offices of the claimants? Both claimants and counsel are mixed on this. The claimants pleaded the junior and senior staff manual of the third defendant as well as the senior staff career structure, but only the senior staff manual was front-loaded by a motion and nothing was said about the other two documents. For all the assertions and claims of the claimants as to what is permitted or not permitted by the senior staff manual of the third defendant, no reference is made by their counsel to any particular provision of the said manual. No provision of the statute creating the third defendant was either cited. Both counsel are at idem that an employee who complains that his employment has been wrongfully brought to an end must found his claim on the contract of service or condition of service and show in what manner the wrong was done. The claimants did not plead the way and manner by which their employment can be terminated by the law establishing the third defendant or by the manual and how it was violated. The defendants who plead financial difficulties as resulting in the closure of the staff schools have also pleaded that it is not one of the statutory mandates of the third defendant to establish and run staff schools. The claimants have not in any way rebutted this by reference to such mandates in the statute establishing the third defendant. The implication is that if the mandate of the third defendant did not include the establishment of staff primary and staff secondary schools, it follows that the statute will have no provision for the offices of the claimants. That does not mean that the third defendant cannot establish the staff schools and employ the claimants under a master and servant relationship. It appears then that the employment of the claimants was outside the statute and is governed by terms under which the parties agreed to be master and servant. I find that the claimants failed to prove that their employments with the defendants enjoy statutory flavor. 2. Is the employment of the claimants necessarily affected by the closure of the staff schools? It is the case of the defendants that the closure of the staff schools due to financial constraints constitute force majeure, necessitating the disengagement of the claimants. In the claimant's letter titled Offer of Temporary Appointment, the following provisions can be found. In some of the claimant's letters titled Offer of Temporary Appointment, the following provisions can be found. 1. The appointment may be terminated by either side by a month's notice in writing or a month's salary in lieu of notice. 2. You will also be bound throughout the period of your service by the regulations of the Polytechnic, which may be subject to modification from time to time. While in some of the claimant's letters titled Offer of Appointment, the following provisions can be found. 1. In the event of the Polytechnic being prevented from carrying out the letters of the terms of the employment by force majeure or any other circumstances beyond the reasonable control of the Polytechnic, the employment shall be deemed to have terminated with effect from date of the occurrence of such an impossibility. It is to be noted that the exclusivity of this categorization is not 100%, but majorly. In the letters of confirmation of appointment, which is not 100% uniform, some of the letters contain the following. Your appointment becomes tenable till retirement age, which is normally 60 years. Remember, the claimants were saying retirement age is 65 years. What I see here is 60 years. Even in the manual, what is there is 60 years. Your appointment becomes tenable till retirement age, which is normally 60 years, and shall remain subject to the regulation of the Polytechnic and such condition of service as may be approved by the Council of the Polytechnic from time to time. In the claimant's letters of regularization of appointment, the terms and conditions of the earlier appointment letters are simply incorporated as follows. All other conditions in respect of the appointment remain the same as contained in our earlier letter. Now, the letters of disengagement all similarly read as follows. This is to inform you that the Governing Council of the Polytechnic has directed that the staff primary and secondary schools of the institution be closed down. In view of the above, your services are no longer required. Consequently, you are hereby disengaged from the services of the Polytechnic with effect from Monday, 5th August 2019. In this regard, the Bursary Department has been directed to compute the entitlements of benefits accruing to you, if any. However, this is without prejudice to your being entitled to 1 month's salary in lieu of notice. The close down of the staff schools was not denied by the claimants, but they averred that the close down of the staff school was a surreptitious move by the defendants to technically terminate their appointments or dismiss them from employment and replace them with casual or contract staff, as the staff secondary school were viable, profitable, and efficiently administered. There is no iota of proof of this affirmation before the court. On the whole, the claimants, being professional teachers employed by the second defendant for the third defendant staff schools, and their employment not being statutorily protected, they can be terminated by a month's notice upon closure of the staff schools. I accordingly hold that the employment of the claimants were necessarily affected by the closure of the staff schools. The implication is that the main claim of the claimants failed and is hereby dismissed. 3. Can the claimants be terminated with 1 month's salary in lieu of notice and no more? The claimants plead and prayed in the alternative. The alternative prayer is for an order directing the defendants to pay the gratuity, pension, and other entitlements of the claimants under the third defendant's condition of service, consequent upon the disengagement of the claimants from their employment. The defendants denied this claim in paragraph 26 of the statement of defense. Thus, the defendants shall show at the trial that the claimants are not entitled to be paid any gratuity, pension, and any other entitlement under any applicable manual or condition of service of the claimant's appointment. The defendant's counsel did not show this in his final written address, since it was a trial on the record. It is sad to note that even the claimant's counsel made no attempt at showing the court such entitlements under the said manual or condition of service. Besides the letters of the claimants, the only condition of service before the court is the senior staff manual of the third defendant. The junior staff manual is not before the court. These entitlements are not in the letters. The denial of the defendants that the claimants are not entitled to be paid any gratuity, pension, and any other entitlement under any applicable manual or condition of services of the claimant's appointment runs contrary to paragraph 3 of the letters of disengagement, which reads, in this regard, the Bursary Department has been directed to compute the entitlements/benefits accruing to you, if any. However, this is without prejudice to your being entitled to 1 month's salary in lieu of notice. This paragraph unerringly suggests that the claimants are entitled to entitlements/benefits. The condition of service of the third defendant is incorporated into the claimant's letters of employment. Accordingly, recourse shall be had to the senior staff manual. Chapter 16 of the manual provides for pension and gratuities in paragraph D, V as follows. D. Pension and gratuity at the rate prescribed in the annexure shall become payable to a member of staff if one of the following events occur. V. On abolition of office. Appendix A is formula for pension and gratuity calculations based on percentage of final salary. The table shows that persons who have served for 5 to 9 years are only entitled to gratuity, while those who have served for 10 years and above are entitled to both gratuity and pension at the rates therein prescribed. I hold that since the employment of the claimants were also subject to the third defendant's regulations, the claimants, after being disengaged for services not required, are entitled to the gratuity and pensions prescribed by the said manual on ground of having been disengaged as a result of abolition of office. This excludes claimants who are junior staff, as there is nothing in respect of their pension and gratuity before the court. On the whole, it is the finding of this court that while the main claim fails, the alternative claim succeeds with respect to senior staff, and same is granted in the following terms. 1. All senior staff of the primary and secondary staff schools who have served for at least 5 years to 9 years are entitled to gratuity as per Appendix A of the Senior Staff Manual. 2. All senior staff of the primary and secondary staff schools who have served for 10 years and above are entitled to pension and gratuity as per Appendix A of the Senior Staff Manual. The defendants are hereby ordered to calculate and pay the senior staff their gratuity and pensions accordingly within 30 days of this judgment. This is the judgment of the court and it is entered accordingly. So let me take your appearance. Okay, Chinda.
My Lord, please, Honorable Court. I, Okechinda. Amen.
Hi.
I, Okechinda. OKE hyphen.
Yes, it's on the screen. It's on the screen.
That's right.
Appears for the claimants.
That's right.
Are you holding brief or you are in the office of Ayenaki?
I'm in the office. I'm with the brief.
Okay, that's good. So let me take your comments so that I go to Olusegun Akeredolu.
Yes,
I've taken your appearance. What is
we
your
are very
comment?
grateful, my Lord.
He said?
Sir?
You said?
Hello, my Lord. I said, we have no objection to the appearance of the learned friend. But in our comment,
not even so you cannot object to his appearance. I'm talking to Okechinda. I said I have just delivered judgment. I have taken his appearance. What is his last comment on the judgment? The usual last comment, the hypocritical comment. Please let me have you on record.
My Lord.
My Lord, we have no critical comments at the moment. We have no critical comments at the moment.
No, the usual we are grateful or what now?
Oh, we are not grateful. Either we are grateful or we are not grateful.
I just, as the court pleases. As the court pleases.
So what did you say?
As the court pleases, my Lord, we accept the court's decision.
Okay. We have heard the court's ruling. You see why I said the hypocritical comment is that usually whether you like the judgment or not, you appreciate the court. You say we are grateful for the judgment. It is when you go to the court of appeal that you will say you are not grateful. The court did not give you justice. The court erred in law.
Well, my Lord,
it's a professional thing.
My Lord,
yes, I don't know why you have not.
On our part,
why you have put off your video?
Oh, I'm sorry, my Lord.
Yes. I suspected why you put off the video at the point you put it off, but I didn't expect that it would last this long. So what is your comment?
Well, my Lord, we are very grateful for that beautiful judgment.
That is how, that is the language.
Yeah, we want to believe
that even though you may not truly be grateful, but you cannot say that to the court. You can only say that to the three wise men. That look, my Lord delivered judgment on so day, and we were not happy with the judgment. We are not satisfied. And this is our reason, isn't it? You can only say that one before them, not before me. That's why we say the hypocritical comments. So thank you. You are welcome, gentlemen.
Thank you, my Lord. We are grateful, sir.
Yes.
Yes, sir. My Lord, sir.
Yes.
We don't know when the judgment is likely to be on the
today. You know our practice in this court. You know our practice. If you come tomorrow, you will get your copy.
Thank you very much, my Lord. We are grateful, sir.
Thank you. Okay, and I think that is all for this case, and that is all for today's sitting. So I think you can just go out because I am not the host. So you can leave.
Thank you, my Lord.
Yes.
Thank you.
Me too. I'm
Thank
only
you, my Lord. We are very
leaving
grateful for that, sir.
I'm not the host.
Thank you.